To all members. Does everyone have the Raskin Amendment? Does everyone have it?
She's not going to read it.
Okay. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute as offered by Mr. Raskin of Maryland.
Without objection. The amendment is considered as read. I reserve a point of order. The gentleman from Maryland is recognized for 5 minutes to explain his amendment.
Thank you kindly, Mr. Chairman. Since we haven't read the amendment, I'm just going to work through the basic terms of it. Resolved that the initial deadline for Hunter Biden to comply with the subpoena issued on November 8th was December 13th, 2023. Resolved that current members of Congress and 3 members of this committee have refused to comply with subpoenas duly issued under the authority of the United States House of Representatives, including Mr. Biggs of Arizona, Mr. Jordan of Ohio, and Mr. Perry of Pennsylvania. Resolved that the aforementioned members of Congress have firsthand knowledge and information related to the January 6, 2021 attack on the Capitol and on this body and on the Vice President of the United States that is of critical importance for the American people and the work of this committee. That the deadline for Hunter Biden to comply with the November 8th subpoena be changed to the date upon which the aforementioned members of Congress supply their knowledge and information to the Committee on Oversight and Accountability. In other words, Hunter Biden has until the date upon which our own members comply with the subpoenas that were issued in the last Congress that have still not been supplied, and that the aforementioned members of Congress shall be ineligible to vote on matters pertaining to contempt of Congress considered by this committee until the date upon which the aforementioned members of Congress supply this knowledge and information to the Committee on Oversight and Accountability. In other words, you should not be standing in judgment on contempt of other people who allegedly have violated their subpoenas when you have violated a subpoena and have not complied with the orders of the U.S. House of Representatives. I would also like to raise a problem that struck me as I was looking through the paperwork on this, Mr. Chairman, which is that the subpoena that was sent to Mr. Biden, which came around a week before, or a couple months before, it was issued on November 8th, 2023, was issued before the House of Representatives had voted on impeachment. I remember there were numerous Republican members who were very hesitant about voting for it because of the testimony of the majority's own witnesses who said there was nothing closely approximating a quantum of evidence that would justify impeachment. And so there had been no vote on it, you'll recall. And on November 8th, the subpoena was issued. The subpoena date for appearance was on December.
Mr. Gosar has a point of order. State your point.
Yeah, we're not talking about impeachment. We're talking about impeachment inquiry. We need to be very considerate about that.
Well, exactly right. And that goes right to the point of this question I have. Thank you, Mr. Gosar. The subpoena was issued on November 8th for a subpoena date of appearance on December 13th. And that was the same date when, you'll recall, we were called to the House, and then there was a vote on impeachment. So the underlying subpoena here is at least arguably invalid for the purposes of holding him in contempt of not complying with the subpoena related to impeachment. And I wonder if we could clear that up. But in any event, I would press the amendment. Certainly those members who have outstanding subpoenas from the U.S. House of Representatives who blew off the subpoenas should turn over what they know about the violent attack on the U.S. Capitol, the worst domestic political violence designed to overthrow an election in American history at the Capitol. And they should turn that over. And at that point, then yes, I will. We will yield in 1 second. And then Mr. Biden should also be forced to comply at that point. In the meantime, those members really should not be voting on contempt motions related to other witnesses. And somebody had a question.
I did. You yield?
Yes.
Are you sure that everybody up there actually received a subpoena? I mean, your board says certain people received a subpoena. And in my experience, some of those people up there did not receive a subpoena, and so notified counsel for your bogus J6 committee.
Well, First of all, every court in the land has rejected the claim there was anything bogus about it. As you know, the courts rejected the idea that it was somehow
Was it heard before every court in the land?
Every court that heard it, do you have any authority on your side for that outrageous proposition? I know you'd like to believe it, but your fantasies are not the law of the United States.
I have great fantasies.
I'm certain you do.
but
You
let
and
me
Ms.
just tell
Green
you
might
this.
want to
What-
discuss them
Yeah,
together.
but you haven't answered the question. You don't know if those people actually even received the subpoena,
but
and yet you
again-
put it on the board, and you're going forward and trying
reclaiming my
to hold
time.
people in
Reclaiming
contempt.
my time. I served for more than a year on the bipartisan January 6th Select Committee to investigate the attack. You might not like Liz Cheney anymore, who was head of your conference, but it was bipartisan, my friends. And so was Adam Kinzinger, who served his country well. But in any event, nobody ever claimed that they hadn't gotten the subpoena. And
Go back and check the records,
Well, if
sir.
that's the argument, have them come forward and explain that. I would like them to testify under oath that they never received it.
Gentleman's
Thank
time's
you, Mr. Chairman.
expired. Chair recognizes Mr. Palmer from Alabama. Chair recognizes Mr. Palmer.
Mr. Chairman, I make a motion that we immediately dispense with the amendment for lack of germaneness.
Okay. I am prepared to rule the amendment is not germane to the bill, therefore the amendment is not in order.
Mr. Chairman, I would like to appeal the ruling of the chair. It's clearly germane. It goes right to the heart of what we're doing here today.
Okay. The motion to appeal.
Arizona is recognized. Mr. Biggs.
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. So, having attended the deposition of Devin Archer, and there were only 3 members of Congress in that deposition, the chairman, Mr. Jordan, myself, Mr. Goldman from the Democrat side. And what I find interesting is that this amendment is moving to strike all of this very important information which demonstrates a criminal conspiracy on the part of the president. So I asked questions. Mr. Jordan did. Mr. Goldman did. And of course, who was the brand that Devin Archer, Hunter Biden, and his Rob Walker, that partnership, what was the brand they were selling? It was Joe Biden. He admitted it. Well, could it be anybody else in the Biden family? No, we were selling Joe Biden. We were. That's what we were doing. So you begin talking, there's money that goes on. You see Joe Biden is involved in the business. He's making phone calls. He's making appearances. Money is coming in and exchanging hands. Shortly after phone calls, shortly after Joe Biden goes to a restaurant to meet with the wife of the former mayor of Moscow, one of the biggest oligarchs in Russia, $3.5 million right into the Biden coffers. They're receiving literally millions of dollars, all linked to this. So we say, well, my friends across the aisle say, well, there's no evidence here. There's nothing here to be seen. But Devin Archer was testifying to that. There are other witnesses that I don't think you've paid attention to who've also said Joe Biden was the brand. He was the product they were selling. Yeah, so you got that on one side. So the question is, can that be corroborated? Then you get a 1023. By the way, the FBI should give us the underlying 1023, which explains why they went ahead with this 1023. Now, the chairman, yeah, there was another 1023, which
Nobody's told me that yet.
Yes, there was. And it's why they went ahead with this interview. So, great minds think alike, I guess. I actually underlined the same provisions that the chairman did. The former president or prime minister of Poland and Joe Biden's son, Hunter Biden, Wojcicki said Burisma hired the former president or prime minister of Poland. So you get the prime minister of Poland's hired to leverage what? The EU, folks. But what was Hunter hired for? To, quote, protect us through his dad from all kinds of problems, close quote. Now, I won't go through the rest of this, but because it also corroborates what Devin Archer was talking about. Hunter Biden's dad was the product, and what was he expected to do? He was expected to do things like was explained in here by a reliable source, to take care of Victor Shulkin. So what else did Devin Archer talk about? He's in Dubai with Hunter Biden. They're at that sailboat-type hotel. They're there, and they're with the president and CEO of Burisma, as well as the treasurer of Burisma. And what are they talking about? Oh my gosh, we're having trouble getting our IPO out because Viktor Shulkin, the AG in Ukraine, is basically going after them. Devin Archer says they excused themselves, and Hunter goes and calls his dad because that's what the CEO of Burisma said, please do. We need help from your dad. We have a recess. They come back. Well, you know, maybe it was just to D.C. What confirms that? The 1023. Don't say there's no corroborating evidence implicating Joe Biden. It's all in this 1023 and Devin Archer's testimony. And then you start using all the other documentation to show very clearly a criminal conspiracy of bribery and selling access on the part of the Biden family. I'll yield to the gentleman from North Carolina.
I thank the gentleman from Arizona. And I'm struck, and maybe I'm...
Well, just before I get on too much more, I have a bill that pulls us out of the World Health Organization. I would encourage all of my colleagues to sign it. If you watched the head of the World Health Organization, Dr. Tedros, today speaking at the World Economic Forum, they are planning to use the next epidemic to impose world governance. I mean, he basically said that. So I invite you to watch that. That's the head of the World Health Organization. Now let's talk about what my good friend from Texas has talked about. And he's been a leader on this issue, and we have both been fighting this for some time. And that is border security. And I can't help but recall the words of President Biden, who was then a candidate for the presidency. And he was asked in the debate on the Democrat side, they said, what do you tell people at the border? He says, I would urge them to surge to the border if he became president. There's a reason that in the Zocalo of Tijuana, people had T-shirts on saying, Joe Biden, let me in. The reason is because he said he would. There's a reason that the first month after Joe Biden issued, I believe it was 90 executive orders undoing the border policy of the Trump administration on the first 24 hours, by the way, that you had the first record of border crossings or these encounters. And that was 150,000. Think about that, 150,000. And our minds were blown. Wow. We're saying, that's more than 5,000 a day. It's a little over 5,000 a day for that. That's incredible. And the next month was more. February is more. March of 2021 exceeded that. Record after record after record until we end up last month with 302,000 encounters. And you begin looking at it and you say, well, how does this happen? Is it just policy? Is it? I used to think it was incompetence. I really did. I want to give, and that's giving them the benefit of the doubt. I thought that after the first 3 months in a row of records, I thought they're just incompetent. They don't quite know what they're doing. And then we got to meet Secretary Mayorkas. He finally came in and he testified. At first, before he testified, he came into the Border Security Caucus and talked to us there. And he said, the border is secure. Now, mind you, just on the encounters alone, for that first 3 months, you were pushing 430,000. For known gotaways, you were pushing about an additional 110,000. Unknown gotaways estimated to be at least another 75,000. So you were pushing 600,000 plus illegal border crossings in his first 3 months that he was running DHS. And he sat there and he told us the border is secure and we have operational control. I will remember when my colleague asked him, do you have operational control pursuant to the Secure Fence Act of 2006? And he said yes. And then we got the language out, right? I think Mr. Roy got the language out and said, let's read the language. And he still insisted. He knew that they were not in compliance with the law. He knew it. And yet he persists to craft a narrative that the border is secure. Of course, it's not secure, which is why you have about 450,000 people entered our country illegally last month. I'm suggesting to America that this country cannot take 12 more months of the Mayorkas security plan on the border. Because to get 12 more months would be over 5 million people into this country illegally. And what's happening now is they're releasing approximately 80% of everyone who comes in. They release them into the country. So when I was in Lukeville the week before Christmas, Lukeville is actually the hub right now and has been. Over a 2-week period, they had 30,000 people come through. Lukeville. Nowhere else, Lukeville. And so I was down there in the heart of that, and we went and I was allowed to talk to people who had not been formally arrested yet. And I would go up and I would ask them, where are you from and where are you going? And why'd you come? Those are my 3 questions, really. And so we had the gentleman from Burkina Faso, another few from Senegal, another few from Guinea. And those are all African nations. Then we had the folks from India and the folks from Pakistan. That's South Asia. India, South Asia, Pakistan is considered to be the Mideast, although in my mind they're still South Asia. That's interesting. Then we of course, we always have some folks from Guatemala, but you need to understand where Lukeville is. Lukeville's, the reason that you have a port of entry there is because it's on a kind of a highway that goes from Phoenix, from Ajo, down to a place called Rocky Point, Mexico, which is on the Sea of Cortez, and people go down there and recreate down there. So when we ask them where they're going, why are you here? No, so then I say, where are you going? Everyone I asked, where are you going? Everyone they start fiddling around in their backpacks and their pockets, and they pull out a card. And on that card will be 2 or 3 names with phone numbers and an address somewhere in the country. And it's laminated. It's not like this. This is not laminated. Theirs are laminated. And so where are you going? We got the guy going to the Bronx. We've got people going to Missouri and Oklahoma, Houston. I said, so why, if you're going to Houston, why are you crossing in Lukeville, man? You should have been over there in Del Rio or RGV. I don't know why you're here, but when you ask them that, because they were directed to come there, the coyotes, the cartels tell them, this is where you're going to go. You're going to come in. So they release them, and they're in good shape. They're in good shape. They haven't walked. They haven't come from the Darien Gap in Panama. Those folks are the folks that are ending up over in Del Rio right now, or Eagle Pass. Those coming to Lukeville, they've come in, they've flown into Mexico, they've been bussed up, and so that they get bussed. How'd you get here? Well, we came in from, there's a gap in the gate, in the fence down here, right? So this border wall that President Trump put up, 30 feet high, but just on the other side, going down to the Sea of Cortez, like I told you, there's a freeway. And the cartels will come up, and they'll run a real quick couple of cuts. They'll remove 2 slats in the fence, they'll pull them down, and they will just start flooding people through. Talk to the guy who repairs them. That morning, in about 4 hours' time, they'd already repaired 6 breaches. And I tell you these things so you understand how real this is. And our lever as members of Congress is the purse strings. And we're not going to have success with just policy, because this is a lawless administration. We have got to have enforcement as a condition of funding this government. With that, I'm going to yield as much time as he will consume to my good friend from Maryland, Mr. Harris.
Thank you. I want to
So my extreme Marxist colleague, who is a mindless follower of Joe Biden, raised the specter of insurrection and lawlessness. And the lawlessness that she was talking about is January 6th. How about the stinking lawlessness at the border every day? Title VIII is violated every day by this administration.
Can I raise a point of order?
The Title VIII.
Just hold on the time. The gentlelady has a point of order.
Can we ask members of the committee not to cast aspersions upon members of the committee?
We had aspersions cast upon us by your member, ma'am.
Yeah, I mean, my observation is that extreme MAGA is used on a daily basis by the second, and so
Repeatedly.
saying extreme Marxist is fair game. You'll have the gentleman from Arizona continue.
Thank you. So the lawlessness that you see is coming across the border every day, failure by this administration to enforce the law. So let's get back to this. And I would just want to say one other thing. This is relative to what we've heard from one of our panelists. He's conflating, again, immigration law with border security. Now, there's a reason that you have three provisions in the Constitution that kind of address this. Article 1, Section 10 twice, Article 4, Section 4. One is dealing with invasion, and that is the security and safety of the nation, of those sovereign states. The sovereign states that actually created this federal government. The article in Section 10 that Mr. Brnovich brought forward with the authority under Article 1, Section 10, that a state may defend itself when it has been actually invaded. Also, the invasion clause, Article 4, Section 4, that's where we've been talking about. But the import-export clause, that's one I want to get to. Article 1, Section 10. A very unique understanding, but it gets at the heart of this. Expand, please, Mr. Brnovich, in about 30 seconds, your idea of the sovereign authority that rests with a state under the import-export clause, Article 1, Section 10.
Thank you, Mr. Biggs, for bringing up this very, very important point we haven't had a chance to discuss today. The import-export clause provides that states do have the ability to control what kind of goods are coming into their states. And even if you accept the premise of what other members of this committee have talked about as far as states not being able to enforce immigration law, that's generally true. However, states can control what is coming into their states. And so, for example, in Arizona, we have 10 ports of entry. I believe in Texas, there's 28 ports of entry. If the Biden administration wants to create an 11th or 12th or 29th or 30th port of entry, then Congress and the federal government can do that. But the states, at the same time, have the ability to force and channel all people, all goods, and commerce into those lawful ports of entry. So I believe there's a very strong constitutional argument, putting aside some of the other language, but even under the import-export clause, that states have the ability to force anyone coming into Texas or Arizona or California, any other border state, into those lawful ports of entry.
And so we get to the point, it is also, again, just as we were discussing about Article 4, Section 4, the invasion clause, in this clause, this is actually even more explicit. The authority rests with the sovereign state. It does not devolve into the federal government. Why would you allow the federal government then to say you can't have control of import-export, or you can't control and determine what an invasion is, when the sovereign state, and don't forget that the founders intended to recognize the sovereignty of the states to govern themselves. If you're going to turn the definition of invasion over to the federal government, who is violating the invasion clause, it just stands logic on its head. Yield back, thank you. I thank the gentleman for yielding to me. So I want to cover your response that you sent yesterday, Director, to a letter sent not quite a year ago, about 9 months ago, on May 3rd, 2023, by Chairman Jordan. In that, he makes reference to Section 1507 of Title 18 and talks about the very things that Mr. Moore was talking about, which is why I wanted to dovetail with his comments. One of the things that he did is he noted that the training materials provided strongly suggest that the administration's continue to weaponize federal law enforcement agencies for partisan purposes. Now, close quote. Whether you agree with that or not, what he did ask specifically was for the production of documents, and he gave 4 categories of documents. And I'll read to you what those are. All documents and communications between the Marshal Service and the Department of Justice referring or relating to enforcement of 18 U.S.C. Section 1507 for the period of May 2nd, 2022 to the present. All documents and communications between the U.S. Marshal Service and the U.S. Attorney's Office for the District of Maryland referring or relating to the enforcement of 18 U.S.C. 1507 for the same period. All documents, again, same time period for the Eastern District of Virginia, and then all documents and communications between the U.S. Marshal Service and the Executive Office of the President referring or relating to the enforcement of 18 U.S.C. Section 1507 for the same period. The reason I raise that is because in your response, there were no documents included or produced or any communications, and I'm wondering if you can explain what your thought was in not including any of those documents or communications.
Yeah, thank you, Mr. Chairman, and I am aware of the response that we sent to the chairman, and I look forward to working with the committee if there's additional information that you requested, but we provided a response to the chairman.
But you didn't provide the documents, and that's what he specifically asked, Mr. Director. He asked for the documents and communications. And the reason that those are important is because it'll either corroborate, it's going to corroborate somebody, somebody's allegations or the position of the U.S. Marshal Service. Somebody's going to be corroborated, but we're going to get to the truth. And as part of our oversight function, we're entitled to those documents and communications, and that's why I'm wondering when you might provide those to us, or are you telling me categorically that you're not going to provide those to us?
Once again, thank you. I would continue to work with my Office of Congressional Affairs as well as the Department's Office of Legislative Affairs that I know has been in contact with the chairman's team to try to be responsive. We did send a response, as you mentioned, that the chairman should have received it yesterday, but we will continue to work to see how we can be responsive.
So that's really not responsive to my question. Are you going to provide the documents or not, I guess is the question.
I would work with the team to see how we can process the request.
All right. My time is up, or Mr. Moore's time is up, actually. So I'll recognize.
Back, the gentleman from Arizona is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Herr, for being here. Thank you for your report. I've read it. And I think where you and I might have disagreements, there may be matters of opinion and not necessarily the facts as you've reported them. So I want to go over the elements of the offense that seem to have at least struck my craw is the where you put in here twice that the jury would not likely to find intentionality on the part of disclosure in particular. So I want to talk about that for a second. So if it's not willful, we might say an accident, something negligent, careless, that would not necessarily rise to willful or intentional or purposeful, right?
Those are different standards of intent under the law. Yes, sir.
Yeah. So when President Biden misplaced 30 briefing documents in 2010 that had classified material, and they're not sure even if they ever got them all back, or when he was in the Hamptons at a party and he lost what they were calling code words, which is high security information, that wasn't necessarily willful. There was no indication that he purposefully did that. Accidental, negligent. You indicated, don't know if we even got all that information back. We're assuming maybe we did. That would not be willful, right?
As reflected in the report, there were certain categories of documents where when we looked into them and investigated how they got to where they ended up or how they ended up being misplaced, we did not identify evidence of willfulness.
Yeah, and so if something's willful, you wouldn't say it's ignorant, it's not incompetent, it's not accidental. We'd say something like it's willful, it's intentional, it's purposeful. It indicates really a choice, that you have made a deliberate, conscious decision to act in a certain way. Is that fair?
That is fair, Congressman, and as I explained in the report, the standard, the willfulness standard basically can be boiled down to the following things: that you know that what you are doing is against the law when you do it.
Correct. So let's take a look at it. And this has been brought up before. In February of 2017, he's having the discussion with the ghostwriter. He says, he's at the Virginia house at this point. He says, I just found all the classified stuff downstairs. Right? So he knows he's got classified stuff, right? 2 months later, In April, he's at a different location, is my understanding. I think he's now up in Delaware. And as you look at let's look at 105, 106 here. He says, Biden reads from a different notebook entry. He reads aloud from notes summarizing a range of issues. We're talking about U.S. military views expressed there by the intelligence community, the DNI, CIA director. And while he's reading those notes, he says, I can't read my own writing. Do you have any idea what the heck I'm saying here? He asked the ghostwriter. Ghostwriter says, well, something, blah, blah, blah. And Biden says this, some of this may be classified, so be careful. Some of this may be classified, so be careful. Now, my immediate response was, okay, so he knows he's got classified docs. He's looking at this. He can't read it. He's giving this to somebody he knows has no security clearance. So he says, hey, read this, but be careful. It might be classified. And the guy says, okay. Next thing he says, well, I don't know if it's classified or not. I'm suggesting to you, and this is where you and I have a difference of opinion. When you say something like, hey, look, this may be classified, be careful. That warning to be careful because it may be classified, that indicates guilty knowledge. That indicates he might know something more than he otherwise would have. And it indicates, then they go on and they read it. As you point out here, he reads classified information. And it's still classified today. That's on page 106. So when you look at this, it's hard for me to say, well, he was ignorant, he was incompetent, he was accidental. No. He had guilty knowledge. He knew and told the guy that he's going to expose that classified material to, hey, be careful. Be careful. It may be classified. That indicates something a little bit more than mere knowledge. Indicates that he has some intent there. Because the next thing he should have said is, hey, I don't know if it's classified, but we're going to skip over this until that's resolved. He didn't do that. What he said is, read it anyway. Yield back.
Gentleman yields back. The gentleman from California is recognized for 5 minutes.
Fuel, is that correct?
Net zero suggests that it is also using some hydrocarbon-based fuel, but it has been decarbonized.
Can you name the benefits of fossil fuel in and of itself?
Can I name
as an energy source?
Well, it is dense, and it keeps the lights on, keeps transportation going. It's an important part of our energy mix.
It's cheap, it's reliable, it's abundant, it's predictable, it's distributable, right?
It's all of that, and it needs to be cleaned.
And so when you have benefits to the overall benefits, when you talk about net zero and when our climate friends, they don't really include the personal benefits or the economic benefits. Can you name some economic benefits that come from fossil fuels?
Well, clearly our economy has been built upon fossil fuels. Our economy is driven by fossil fuels. But fossil fuels have also created an enormous problem, which is climate change. And that's impacting individuals and economies too. So let's clean it up.
Let's talk about some other things. With fossil fuels, you saw a dramatic increase over the last 130 years of longevity and mortality rates. Is that correct? That's true, right?
Yes.
You also saw a dramatic increase in sanitation and health impacts that were good, right?
Well, I wouldn't know that I would attribute that directly to fossil fuels, but yes, we have seen an increase in longevity, increase in health.
So most, with the number of petroleum-based products that you have out there, it affects virtually every aspect of your life, whether what you're wearing, your health the apparatuses that you use, all of those come from petroleum-based products, right?
Petroleum-based products impact every aspect of our economy.
So PJM Interconnection, the nation's largest grid operator, released a report finding that the amount of generation retirement appears to be more certain than the timely arrival of replacement generation resources. What they're really getting at there is that we're reducing reliable energy resources before reliable sources come online. And that's really what we see happening, and that's the anticipation. That's why some states talk about rolling brownouts that are coming their way. They're very concerned about that. as am I. Let's talk for just a second about electric vehicles, if we can. So the funding came in the IRA, and the federal budget estimated. Let me get this right here. In the 117th Congress, we passed the IRA. My Democrats colleagues did anyway, and they provided. CBO and JCT estimated that the eliminate spending and tax breaks would cost around $400 billion by moving to electric vehicles, commercial electric vehicles, heavy-duty electric vehicles, tax credit for residential charging equipment, and $3 billion for postal fleet electrification. That was, they estimated that would have a net of $400 billion cost. Since that bill has passed, now for those same programs, the estimate is that the subsidies will be $1.1 trillion over the same period of time. Now, of that, $7.5 billion was generated for nationwide electric vehicle charging infrastructure, and yet it's been reported that we have now 4 charging stations, I believe it is, and that was reported by NBC. Does that sound accurate to you?
No, it doesn't.
Well, tell me how many new charging facilities do we have? I'm sorry, 7? 7. There's been 7 built in 4 states.
So let me just explain this. The National Electric Vehicle Initiative required states to develop a plan in order to be eligible for that $7.5 billion. All states did. We approved all of those plans. All of the funding has been released to the states. These are all state programs. So now 36 states have released solicitations to be able to build out those charging stations. 22 states have announced awards. There will be an additional 2,000 stations built by the end of 2024.
You're guaranteeing that there's going to be 2,000 EV stations?
That is what we forecast.
And that's your forecast. And the result is you're putting those in, the taxpayers are putting those in. All of these are taxpayer subsidized, and yet Ford can't even sell their cars. Most of these lots can't sell them. I would like to introduce into the record the article where Ford is announcing massive losses of $1.3 billion, that they're losing on an average $132,000 for every EV that they sell.
Without objection to ordered.
Thank you.
Gentleman yields back. Chair now recognize Mr. Lynch from Massachusetts.
Thank you, Mr. Chairman. Welcome, Madam Secretary. Good to see you. Thank you for all your good work. Just really quick on Leahy.
From Arizona is recognized.
Thank you, sir. Director, have you ever been a cop?
Excuse me?
Have you ever been a cop?
I have not been a police officer. I was a prosecutor.
Yeah. So you don't have decades of law enforcement experience, but you said you worked with law enforcement, right? That's fair to say, right?
I was a prosecutor for over 20 years in 5 different offices.
You worked with law enforcement. You weren't law enforcement. So is it common for ATF to turn off the power to a location prior to executing a search warrant?
Is it common for us to do that? Yeah. I do not believe it is a common thing that we do.
You're the director. You either know it is common or you don't know whether it's common.
I thought I answered the question. I'm sorry.
Is it common?
My understanding is it's not common, and I want to be very careful to say I'm not commenting on any case because I'm not sure until the facts come in.
Did I ask you about a specific case, sir? I did not, did I? I asked you about policy. You just said it's not common. Next, does the ATF use RF frequency jamming technology to prevent the internet and cell phones from working?
Sir, I'm sorry.
Does the ATF use RF frequency jamming technology to prevent the internet and cell phones from working during the execution of a search warrant?
Again, I am not going to sit here, and I guess I maybe should have said this before, and comment on the tactics that we use when we go into dangerous places, because it provides a blueprint for criminals to hurt us.
Let's get this straight then. You told us you won't answer anything specifically about a case. Now you're saying you're not going to tell us generically.
Maybe we can contact your staff in private setting and have a conversation instead of broadcasting for all the criminals.
Does the ATF use dynamic entry as their means for entry during the execution of a search warrant? Does the ATF still use dynamic entry as their means for entry during the execution of a search warrant?
Again, I don't think it's appropriate. We can communicate with you on these kinds of training issues. I just don't want to give a public blueprint for people tomorrow and the next day who are going to be facing law enforcement through the door to know how we're coming, what we're doing.
Do you assess pattern of life as a part of risk assessment conducted prior to executing a search warrant? Can you answer
I think
that
that's
one?
far enough afield that I could say, depending on the case, we can assess pattern of life at times, of course. Depends on the case, right? Some cases it's appropriate, some cases it's not. These are career, I don't do this, right? The career law enforcement people, as you pointed out, do this with decades of experience. I don't armchair quarterback them either.
But here's the deal. You're the director, and I would expect that you would know what the policy is. And it looks to me, you've convinced me that maybe Mr. Nels was right. I'm not sure that I thought he was right. But you didn't want to tell us specifically about the Malinowski case. I got that. I think it's wrong. I think it's a false narrative. But then when I start asking you about policies, generic policies, now all of a sudden you don't want to answer those. So when you coordinate with local law enforcement you do coordinate with local law enforcement prior to the execution of a search warrant?
In most cases, yes. Certainly, most of our cases we're doing shoulder to shoulder with law enforcement.
So these are yes or no questions. Thank you for answering yes. Is it the ATF's practice to instruct law enforcement partners to turn off their body cameras when participating in search warrants with ATF?
ATF's written policies that are in our MOUs is that if a local law enforcement agency has a body-worn camera policy and we're going on one of these short-term operations, they are entitled to follow their own policy if they wish. That is in black and white.
Can you tell us the difference on how the ATF would handle a search warrant on a violent felon versus an individual who allegedly sold a few firearms without a license? Is there a distinction in your mind? Is that in ATF's approach?
In every case, we do risk assessment, and it's dependent upon all the facts and circumstances of any particular matter. So in every case we do it, but you can't boil it down to one or two things. It's a risk assessment that experts who are risking their lives conduct.
How does the ATF balance the need for operational security and the need for the safety to the public?
We have to do, you're asking about balancing, I think you said operational security, and we have to keep the public safe. That's obviously paramount. But police officers are entitled to go home alive at the end of their shift also. And we also have to make sure that we're doing that as well. You have to do both.
So you didn't answer the question. The question presupposed exactly what you just said. We know that you have to balance them. How do you balance them? That's the question. How do you balance them?
The answer is both are paramount, and we have to do both in each operation. But I will tell you this. There's no such thing for a police officer as no risk. They sign up, we sign up, the agents sign up to risk their lives. And they often go into very dangerous situations in order to do that, so there's no way to mitigate all of their risk, sometimes very dangerous risk from any operation.
And we understand that. We appreciate that. Now, I have to say that you didn't answer Mr. Massey's, our letters to you. I'm hoping that you said you're going to give us additional responses to the questions I've asked you today. I would anticipate that you'd give more fulsome answers than you gave us regarding the pipe bombing issue.
Gentleman yields back. The gentlelady from Biggs.
Thank you. I thank the gentleman for yielding. You know, during his testimony before the House Judiciary Committee, Special Counsel Herr stated that, quote, the evidence and the president himself put his memory squarely at issue, close quote. In his report, Special Counsel Herr noted that during both his and Zwanitzer's interviews with President Biden, the president's memory was significantly limited. President Biden has contested that. The Democrats contest that. But in reality, it's the failure to fully comply with the committee's subpoenas regarding the audio recordings of the Biden and Zwanitzer interviews that has hindered the House's ability to adequately conduct oversight over Special Counsel Herr regarding his investigative findings and the president's retention and disclosure of classified materials, and has impeded the committee's impeachment inquiry. So, the committee must assess whether the Special Counsel Herr's declination decision, which was based on President Biden's poor mental state, was consistent with the department's commitment to impartial justice, or whether legislative reforms are necessary regarding special counsel investigations because they are not leading to impartial outcomes. In short, the audio recordings would offer unique and important information to advance the committee's impeachment inquiry and inform the Judiciary Committee
as to the need for legislative reforms to the operations of the department or the conduct of special counsel investigations. Those are legislative purposes, they are constitutional purposes, and they justify us getting the audio recordings. But they don't want the audio recordings to come forward. Why is that? It's odd, isn't it? Because the DOJ admitted in court filings 2 weeks ago that they actually did alter the transcript. They claim, oh, there's just filler information. Maybe there were duplicative words. There were blank pauses in there that were not noted in the transcript. That's why an audio recording is important, because the transcripts do not reflect important verbal context, such as tone or tenor, or nonverbal context, such as pauses or pace of delivery, all of which went into the decision by Mr. Hur not to prosecute a crime that he said was committed. That prosecutorial discretion is under review by our committee legitimately and constitutionally. We have the right to that audio recording. The department has said they're not going to give it to us. Odd. Because the cases that deal with requiring the audio recording to be turned over, the long skein of cases, they turn on various things like the audio recording is the best evidence. They say that. Odd. They also say that if there's tampering or any kind of editing or altering of the written transcript, which we now know is true, then the audio recording is mandatory. That's why we should get it. This department won't give it to us. Merrick Garland is in contempt of this Congress, and he needs to be held in contempt. And with that, I yield back.
The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. So I'll ask you, Mr. Bailey, do you know why Alvin Bragg originally declined to move forward with the prosecution of Donald Trump?
I believe the reasonable inference to draw is that the charges aren't supported by the laws or the facts.
So let's talk about a guy named Mark Pomerantz. So Mark Pomerantz and his colleague, Mr. Dunn, resigned from the office because they felt that Mr. Bragg was not going to go forward with the case. And so he issued a statement. But in analysis, if you start looking at what Mr. Pomerantz said, he said, many members of the team did not think that they could prove Trump committed crimes. Many did not think the New York State criminal charges advanced by Pomerantz applied to Trump's conduct. In his book, he writes, many of the lawyers were relentlessly negative. There were references to our case as weak. One lawyer opined that it had many fatal flaws. Another expressed a view that the case may be way out there. It's not the strongest case in the world. If you go on, there were defectors from the Trump investigation. All of this is taking place from December of 2021 all the way through February of 2022. Now, why is that important? Because I want to get to this, Professor Foley, because there's a timeline issue, and you're talking about due process. And so due process is, you've mentioned two pillars, but I'm going to suggest that if you have an infirm prosecution and they're looking to find a way to prosecute because it's a person as opposed to the case. So here's the timeline, which may seem coincidental, but this is exactly what happened. November 7th, 2022, Trump teases. He says, I have a big announcement coming up. September 9th, 2022, at a press conference, Joe Biden says, we just have to demonstrate that he will not take power if he does run, making sure he, under legitimate efforts of our Constitution, does not become the next president. On November 15th, Trump announces his run. Now, here's where it gets interesting. On November 18th, Matthew Colangelo, number 3 in the DOJ, resigns. He gives a 2-week notice in a letter, and he's going to end up quitting his job at DOJ on December 2nd. He's going to work for Manhattan DA Alvin Bragg's office beginning December 5th. And nobody can tell us from DOJ or Alvin Bragg how they even, nobody seems to know. Just apparently, Colangelo just shows up in the office one day. Point 2 on that same date, November 18th, Merrick Garland appoints Jack Smith on 2 cases against Trump, one in Florida and one in Washington, D.C. Number 3, Same day, November 18th, Fannie Willis's paramour, Nathan Wade, spends 8 hours in meetings with White House lawyers. And it wasn't too long after that that indictments start falling into place. And we could go through those. I wanted to ask you, Ms. Foley, if a prosecutorial agency is actually searching for crimes because of an individual, and they've stated it. Don't forget Mr. Bragg, and I'm leaving out all of his campaign promises to get Trump. Couldn't name any kind of thing that he had done wrong, but he's going to get Trump. Is that antithetical to the very notion of due process in and of itself?
Yeah, you ask a really interesting question. Yes, the short answer is yes. There is a line of Supreme Court jurisprudence beginning with a case called Rochin versus California in the 1960s, which establishes what's called the shocks the conscience test for violation of due process. You may remember that from law school. It's where your stomach got pumped forcibly against his will.
Yeah.
But since Rochin was decided, there have been other Supreme Court cases. There's one called X-Rel Vuitton. There's one called Caperton involving judges. And this line of jurisprudence under due process says that if you can establish that there was bias by a prosecutor, an investigator, or a judge that shocks the conscience, it's a due process violation as well.
Right, so when we start looking at this, and you realize that there was no theory of the case that seemed to work. I mean, that's from Mr. Pomerantz's testimony. They couldn't come up with a case. You have prosecutors saying, we just can't find anything here. And then all of a sudden you get jury instructions like you have here. How antithetical to that is to due process?
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias. And, you know, whether or not it would shock, you know, the left side of the aisle's conscience, I don't know, but it certainly would shock mine. I'm trying to be pretty objective about this. You know, it's a high bar to shock someone's conscience, but, you know, basically the idea is, you know, if you're doing the Attorney General Justice Jackson maneuver of picking the man and pinning some crime on him, then yes, I would hope that would shock your conscience.
Thank you. Yield back.
Gentleman yields back. Gentleman from Tennessee is recognized. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. You know, Joe Biden knew that Zwanitzer did not have security clearance. He also knew, Mr. Zwanitzer knew he didn't have clearance. And yet, in the process of all this working on the book, Mr. Biden chose to read and disclose classified information. So I get when our colleagues on the other side of the aisle said Joe Biden was talking to Mr. Zwanitzer, his ghostwriter, about sensitive things. They're right. Classified things that have, many of those entries remain classified even today. And her report is replete with that. Joe Biden says, do you have any idea? This is on page 106. Any idea what the heck I'm saying there? As he hands him a classified document. Mr. Biden then reads information to Mr. Zwanitzer. Mr. Zwanitzer reads the classified documents and puts it out there. What's interesting to me is when you talk about that Joe Biden's talking about the tragic death of his son, Beau, and we all have respect for that. But there's a whole chapter in Mr. Herr's report about the classified Afghanistan documents that Mr. Biden retained and shared with the man without security clearance, Mr. Zwanitzer. And yet, we're told that we need to wait longer. That's what we just heard is don't do it today. You don't have to do it today. Just the fact that for 2 months, about every 7 days, you were having contact and communication with Zwanitzer's attorney, that's not enough. You got to do more. And that's really unfortunate here. But then when we get to the real crux of this with Mr. Zwanitzer, when he finds out what's going on, what does he do? He deletes his information. He destroys evidence. That's what he does. He destroys evidence. And so I find that really intriguing. And when we get down to the nub of this, did Mr. Zwanitzer have the opportunity to actually ameliorate this? And the answer is yes, he did. Did he choose to ameliorate it? No. Could he cure contempt? Maybe he could. He's not indicated any desire to cure contempt at this point. And the bottom line is, ultimately, was he issued a subpoena by a committee, a real committee, that had authority to issue that subpoena? And did he respond to it, or did he say, look, I'm not going to respond? And he said, I'm not going to respond. Well, now...
Will the gentleman yield for a question?
No, I'll yield to you, just like Mr. Swalwell tried to engage in a colloquy where he then refused to take answers.
I always allow people to yield when I'm speaking.
So, you know, Mr. Ivey, you do, and I appreciate that. But the bottom line is, you have a situation here. Subpoena's been issued. There's been discussions back and forth, which in my mind meets what the court said. Then not only do you have the discussions back and forth, he basically says, I'm not going to provide the information. Now you're left.
Thank you. I yield back.
Chair recognizes Mr. Biggs from Arizona.
Thank you, Mr. Chairman. Thank you, witnesses, for being here. Andrea Lucas, who is a commissioner of the EEOC, published an article warning that race-conscious corporate diversity programs may violate Title VII of the Civil Rights Act, which prohibits employment discrimination on the basis of race, color, sex, religion, or national origin. Mr. Rokita, in your written testimony, I'm quoting from it now, it says, DEI programs that consider a job applicant or employee's race or color in hiring, retention, promotion, and other terms, conditions, or privileges of employment could be considered unlawful under Indiana's Civil Rights Act. Is that also true under federal law?
Thank you for the question. Yes, Indiana's law in several respects mirrors the federal law. So the point there I was making is that Title VII prohibits race-conscious employment actions, period, full stop. It doesn't matter how the program's labeled.
Ms. Stepman, is that how you say that? Okay. In your written testimony, you say something similar. It said, instead of upholding a system in which all employees, regardless of their race, sex, or other characteristics, irrelevant to work performance, are judged on their merit, talent, qualifications, grit, intelligence, or any other of the myriad qualities that make a good hire, too often, Title VII in practice as it exists today not only fails to do so, it does the opposite. How so, and can you expand on that, please?
Sure. Again, we have this same story of over and under enforcement. On the one hand, completely ignoring publicly delivered and announced racial quotas, and I'm sorry, announcing that 30% of your workforce will be of a particular race by a particular date is a quota. It is an obvious quota. It's the kind of obvious quota that even university admissions departments cannot say or are reluctant to say even before SFFA, and it's forbidden by Title VII. Somehow, these companies have very little fear of announcing these things to the press, and while, on the other hand, they do have to be careful when, for example, as the Sheets case that's been repeatedly brought up here, they use a neutral qualification, like not, or screening out job applicants who have felonies on their record. The sort of policy considerations about that, about mainstreaming, inmates back into society, those are irrelevant to the point. This is a neutral qualification that the employer is using, and yet they find themselves, having to show being on the defensive and having to show this very tight connection to the job in the way that the EEOC enforces Title VII. So on the one hand, we have a neutral qualification that is, and people are being hauled into court for using it. On the other hand, we have blatant racial quotas that are being ignored by the EEOC.
So, Mr. Berry, you wrote the EEOC has defended DEI initiatives in the workplace even when those initiatives create the very Title VII violations that the EEOC is entrusted to stamp out. Expand on that, please.
Certainly. So the Commission has taken the position we've seen a couple times today, which is to equivocate between the existence of disparities and actual intentional discrimination. And repeatedly, over and over again, the Commission has declined to take action against companies that are saying the quiet part out loud. They are saying, we are going to have, come hell or high water, greater percentages of certain racial categories reflected, not because we've done a labor market analysis, but because we think that a certain kind of racial balancing is appropriate. The exact kind of interest the Supreme Court has said is grossly inappropriate.
And so does that get to what you talk about in your testimony extensively about disparate impact liability?
Yes, exactly. Disparate impact liability is very inconsistently enforced and is not being brought to bear, as best I can tell, against the widespread practice of college degree requirements as a screening mechanism.
Mr. Rokita, is tying one's continued employment or pay to statistical data, which Ms. Stedman has talked about as being perhaps a quota, is that in any way aspirational and protected?
No, I don't think so.
Ms. Stedman, any comment?
Yeah, I guess my only comment would be that I agree with my fellow witness that the real disagreement here is whether any disparity, whether racial or sex on any other basis, is suspect immediately as created by discrimination. There are disparities in everything. There is virtually no qualification that an employer could ever set that would have no race or sex disparities. So that's when the EEOC looks at the issue in this way, what it really does is expands its own power because it's arbitrary. Whatever issue the EEOC looks at, whatever qualification will spit out some kind of disparity. But they don't look at other qualifications, as my witness also said, my fellow witness. For example, using college degrees as a qualification. Fewer men have college degrees. Fewer Black Americans have college degrees, right? Those are disparities that exist, but the EEOC doesn't look at that qualification and say, well, it's against our civil rights law to require a college degree, probably because that would be very unpopular with their friends in universities.
Thank you, Mr. Chairman. My time's expired.
Gentleman's time's expired. Chair recognizes the gentleman from Arizona, Mr. Biggs.
Thank you, Mr. Chairman. I request unanimous consent for that photo to go into the official record.
Without objection, to ordered.
Thank you. Director, your agency has a no-fail mission, and on Saturday, July 13th, your agency spectacularly failed. The failure resulted in the death of Corey Comparator and serious injury to two other rally attendees, David Dutch and James Copenhaver, besides the injuries to President Trump. It is unfathomable that a 20-year-old on the radar of Secret Service and local law enforcement before President Trump went on stage was able to climb onto the roof of a building with a rifle and fire off multiple rounds before he was neutralized. Was Mr. Crooks acting alone?
Again, I would have to refer you to the FBI's investigation.
Was he just a lone gunman?
I would have to refer you to the FBI's investigation for motive.
What did the Technical Services Division determine was going to be the event perimeter?
Those are questions that we are asking, and we are
you're sitting here today. Come on, Director. Everybody said this. You knew you were going to be asked that question because it's been asked multiple times. So this is an easy one. What did they determine was going to be the event perimeter? So you should know that. I mean, this is not, gee, I got to wait till someone else tells me. What was it?
Again, I don't want to speak to specifics of the event.
Okay, this is a specific.
I understand.
This is a specific that you ought to know. As someone who said the buck stops with me, I'm going to stay in my job, I'm going to give the answers to the American people, and I know what happened, except for you're not going to tell us. And you're not going to tell the American people. And you yourself said in an interview that foments this notion of conspiracy theories. Guess what? When you sit here and repeatedly tell people, hey, I have to wait, as frustrated everybody on this committee, guess what? It undermines your credibility and whether you're really going to get to it. So I'm going to ask you again, what did the Technical Service Division determine was going to be the event perimeter?
We are still gathering reports. We are interviewing individuals.
You know what it is, though. No, you're just not going to tell us, right?
When I have those details, I will most certainly share those.
Was the gun already on the roof, or did the shooter carry the gun up with him?
I do not have that information at this time.
Well, when was the last sweep of that roof done prior to the rally?
I do not have that information at this time.
So
How many holds? I mean, so most of us here have been in events, and Secret Service has been there. There's been security, and I can't tell you how many times we've said there's going to be a security hold right here. So we're going to wait, and we wait to 1 or 2 or 3 minutes, and yet we're hearing from you apparently that there were no holds in place. So ever instituted here with President Trump's going on stage. And you said, and this is, I think, connected with this, you said they hadn't adjudicated the shooter to be a threat. He was adjudicated to be a suspicious person, even though we've got some dynamic video that Mr. Krishnamurthy put on the video for us. So I guess my question for you is, and I think you answered this, I just want to see if you're consistent with what you said about an hour and a half ago. What do you do if a suspicious person is identified by the agency?
So at a number of our events, it is not unusual.
I know it's not unusual. What do you do?
Those individuals that are identified as suspicious, we will send teams out
Was a team sent out here then?
There were teams that were sent to identify and interview that individual.
They were sent to interview the individual who's scampered up in camo on top of a roof within 130 yards of his target. And did your team get there? When did your team get there to conduct that interview?
I don't have the details on the timeline. It is my understanding.
So if you did send, if they did send a team and they're going to interview him, and you described that earlier as an investigation, why didn't they put a security hold on President Trump going on stage at that rally?
At a number of our protective sites, there are suspicious individuals that are identified all the time. It doesn't necessarily mean that they constitute a threat.
Of course not. But here you got a guy scampering up the side of a building on top of a roof. It's identified to you, and you said you sent a team there. And you can't answer that. And this gets to one of my finer points, Mr. Chairman, if I can make it. And that is, we can have these kind of interview sessions, 5 minutes, everybody gets a kiss at the pig, 5 minutes, and she gets to stonewall us, not deliver answers. So we say, okay, we're going to put together a congressional committee, a blue ribbon committee. Same crap will happen. I am calling, and I'll support that, but I will tell you this, I am calling on the Speaker to give us and put together a truly independent commission of qualified former Secret Service agencies, presidential and VIP protective services people who can actually conduct this kind of investigation and give us real answers, because I don't think you're going to give us those answers. You should have come today ready to give us answers. I call upon you to resign today. And I also would say I've got a bunch of UC requests, if I can go ahead, Mr. Chairman.
Proceed with the request.
Thank you. I apologize. It might
That's all right. Go ahead.
It might take a moment.
Very important.
Anthony Guglielmi, the Secret Service spokesman, one from him.
Without objection, so ordered.
Article, U.S. Secret Service says it previously denied Trump requests for additional resources, New York Times reports.
Without objection, so ordered.
Secret Service says it denied earlier Trump requests for more federal resources.
Without objection, so ordered.
Secret Service acknowledges denying some past requests by Trump's campaign for tighter security.
Without objection, so ordered.
Preliminary findings by Senator Ron Johnson and his committee.
Without objection, so ordered.
Articles entitled, Notice Anything Different About Trump's Secret Service detailed. Next, former Biden official corrects herself after saying Dems must turn their fire on Donald Trump to beat him. Secret Service director says buck stops with her, but she will not resign. Disney Star Wars Mark Hamill cracks joke about Trump's ear bandage following assassination attempt. Biden, I haven't engaged in inciting rhetoric. Trump has. I'm just talking about threat to democracy. Piece called Who is Secret Service Chief Kimberly Cheadle? Charlemagne the God says Trump solely responsible for violent rhetoric that led to attempt on his life. Video actress Amanda Seales pushes conspiracy theory Donald Trump assassination trip was staged. Report Secret Service identified rooftop as a potential vulnerability days before the rally. Watch BlackRock removes ad showing former President Donald Trump's would-be assassin. Why does the Biden administration have 100% confidence Secret Service after assassination attempt? Secret Service director, we didn't put snipers on the roof because it was kind of sloped. Here's what Thomas Matthew Crooks did in the days leading up to Trump assassination attempt. Secret Service Director under scrutiny for diversity initiatives after Trump assassination attempt. The official story on Trump shooting makes no sense at all. Andrew McCabe says Trump assassination.
Mr. Chairman, point of order. I'm happy to assent to all of them. I just so as to facilitate
You don't want me
our
to read?
proceedings.
Is it too tedious?
Well, we're not even really hearing them anyway. So if we could, it's up to you, Mr. Chairman.
You would like me to slow? I'll slow it down. I was probably going too fast. Secret Service's explanations for security failures ahead of Trump assassination attempt are not adding up. U.S. reportedly received intel of Iranian plot to assassinate President Trump. What WTH, Secret Service now saying that they didn't put any agents on the roof because slight slope was too dangerous. Report, U.S. officials received intel of Iranian plot to assassinate Donald Trump before Crooks' attempt. Exclusive GOP rep cloud. Homeland Security Agency is interfering in House's assassination investigation. Why Trump's raised fist after surviving assassination attempt is triggering the liberal media. Questions swirl over the security lapse at Trump rally, reviving old concerns about Secret Service. Secret Service scrambles to shift blame after Trump shooting as backlash hits hard. Nobody contacted me. Must-see 6-camera split screen of assassination attempt captures everything shooter was in open 2+ minutes. Murillo, 5 reasons you should be angry. Breaking, shooter spotted up to 30 minutes before firing, reported multiple times. Pictures taken, no one stopped him. Cheadle calls the 30 minutes between noticing and neutralizing shooter a very short period of time. Secret Service Director says buck stops with me on Trump assassination attempt but won't resign.
Mr. Biggs, we'll stop right there. We can retake them on the next one. I know there are more,
Okay.
but without objection, we'll enter into the record.
Thank you, Mr. Chairman, and thank you, Director Wray, for being here. How many shots did the shooter fire?
Well, we know that he fired at least 8 because we recovered 8 cartridges on the roof.
Okay, and are all the cartridges and the unspent bullets, have they been, you know how many there are? You've accounted for all of those? I assume, yeah.
We believe we have. Again, there was lots of work still ongoing, but yes, we believe we have accounted.
And did the recovered shells, the cartridges, match the shooter's rifle?
My recollection is yes.
And you conducted analysis that confirms that?
Well, we work with ATF, but yes, so some of the work has been divided up. But.
And how many shells casings were recovered from the location of the counter snipers?
I'm sorry, I couldn't hear the last part.
From the counter snipers location?
That I don't have the answer, at least here at my fingertips.
Okay. Did the blood and tissue pattern of the shooter, did it match the stories or the witness testimony that you've heard so far?
Can you, well, I'm not sure I'm following the question.
Well, I assume you've interviewed the counter snipers, or you have that evidence, and other witnesses describing the kill of the shooter. And I'm wondering if the blood and tissue and brain matter is consistent with the testimony that you're receiving. In other words, is the physical...
In terms of the manner of death?
Exactly. Is the physical evidence consistent with where the shot from the counter sniper took place?
Yeah. So the autopsy is being handled by, as is not unusual, the state authorities. My understanding is, thus far, I don't think it's fully complete, which is not, again, not totally unusual. But so far, nothing remarkable on that front.
That's from the body itself, but from actually the scene where the shooter was found, is everything consistent with the testimony, the physical evidence at the scene? Is that consistent with the testimony you've seen, that you've heard so far?
So far, yes. Again, ongoing investigation.
Were you able to determine whether the shooter took the gun up with him when he climbed up to the top of the roof, or was it already placed there somewhere?
So that is something that we're drilling into right now that we don't know the answer to yet. I can tell you, which may be relevant, though, to your question, that, and I don't think this has been reported yet, that the weapon had a collapsible stock, which could explain why it might have been less easy for people to observe, because one of the things that we're finding is people have observed him, the first people to observe him with the weapon were when he was already on the roof, and we haven't yet found anybody with firsthand observation of him with the weapon walking around beforehand. So that doesn't mean he wasn't, obviously, but the collapsible stock is potentially a very significant feature that might be relevant to that.
Did he have a scope?
I believe so, but as I sit here right now, I don't remember.
Okay. You mentioned about 2 hours before the incident that he'd had a drone and he was using a drone. Instead of me putting words in your mouth, just tell me how you discovered the drone, how you discovered the time, and how you discovered, if you can describe what he would have been observing with the drone and how you determined that, please.
So this is something that's very much ongoing right now. We're going back and forth with our lab as they continue to do work on it. What I would say is the drone was in his car. As I said, we've been able to, by exploiting the drone, determine its use and flight paths. There were no pictures or videos on the drone of the day of the rally, for example, but we have been able to reverse engineer the flight path of the drone from the day of the rally, and that's how we know that for about 11 minutes, from I think it's around 3:50 p.m. to 4 p.m., somewhere in that range, he was flying the drone, and we have the flight path. It's about 200 yards away from where former President Trump would ultimately be speaking. And so that would have primarily given him a vantage point. I'm trying to think how to describe this. If the former president's podium is that way,
yeah,
the drone would be over here looking, say 200 yards again off this way, looking back. So it would have shown the shooter, we think, again, we're still doing more work on this. I really want to qualify what I'm saying, but I'm trying to be transparent and lean in here. We think it would have shown him kind of what would have been behind him.
But when you say behind him, behind the shooter?
Correct. Like, in other words, almost like giving him a rear view mirror of the scene behind him, except again, he wasn't flying it overhead while he was later back for the assassination.
But he would have had, with the drone, he would have been able to also assess kind of, because the stage, I assume, was already set, he would have been able to assess that angle with the rooftop as well, forward and backward, I assume.
Well, certainly going towards the podium. Again, we're still trying to figure out exactly what he saw, because we're having to, in effect, because there's no recording of what he saw during those 11 minutes, our hypothesis at this point, the experts think he would have been live streaming it. And so we're trying to, in effect, say, okay, if this was the flight pattern, given these capabilities of the drone, what would you have seen? What could you have seen for those 11 minutes? And again, it wasn't over the stage or the kind of the hub of the rally. It was about 200 yards away, but it looks like it would have been looking, let's say, length of a football field or so, more, kind of towards the podium.
Great, thank you, Mr.
Thank you so much. We're now going to go into our second round of questioning, and again, I appreciate the panel and all that you guys have been providing in regards to expertise and on-ground truth realities. We're going to continue to move on, going back to the Honorable Andy Biggs. You're recognized for 5 minutes.
Thank you so much. I want to just try to hit some quick questions. When Mr. Schaefer, you were talking to us earlier about moving to texting. The counter snipers were texting. What does that do with your ability to stay on glass?
Was a secondary or possibly even a third method of communication as it was utilized that day. The sniper teams in the law enforcement concept sometimes are not a team. Sometimes we're deployed into situations where we're a single operator. So we're not only responsible for the surveillance aspect of the service we provide, but also having that deadly threat ability on board. So that can be very distracting in that point in that day. That third level of communication would have pulled us away from our primary responsibilities to provide that deadly cover if needed.
Thank you. And Mr. Prince, you mentioned security bubbles. And
I want you to elaborate on that because we've talked a little bit about the perimeter. And the perimeter seems oddly narrow in this particular instance. Can you talk about security bubbles and the perimeters here?
As Dan was talking, right, the normal of that bubble is out to 1,000 yards based on how far a capable sniper can take a shot. The fact is, clearly this bubble was less than 100 yards because they disregarded the industrial facility, the water tower, et cetera, and it speaks to the lack of seriousness of Secret Service leadership in how they were conducting these missions. I don't think they regarded Trump as a worthy protectee. They were doing the absolute minimum. And I say my greater concern is as you look at all the litany of failure is long and deep. And if it tips towards malice, that opens up an entirely different can of worms.
Right.
Because it's hard to be part of a republic with people that actually want to kill you.
Right.
Political disagreement, fine. Sell it at the ballot box. But if people don't want to sell it at the ballot box, then it gets sold by a cartridge box. And that's a very, very dangerous road to go down.
Right. And well, we could go on that. I know some of my colleagues might want to do that as well. But I want to get to one last point, and that before I run out of time, and that is another failure. I think everybody here is probably, everybody up on this group anyway, has been with a president or a protectee, and there's been some kind of security hold. I mean, we've just stopped, and you say you're going to hold. Why was there no security hold put on Trump at any time if you had some kind of individual? I mean, that Mr. Schaefer has described actually did arise to a threat level. Why was there no security hold put on President Trump? Why was he allowed to go on the stage? Why wasn't he taken down? Why didn't we see a pause?
For me?
Yeah, Dan.
What makes your question even more impactful is every Secret Service site for a high threat level protectee has what they call a holding room, which you would guess is for holding the protectee. I see Congressman Gacy because it's actually called the holding room. Yeah. The holding room is for things just like this. The holding room is, let's say a congressman shows up and is a little late. There's an accident. They'll hold him in the holding room saying, "Enjoy." You all have been in it. None of this is new. You've been in the holding room. There's a Secret Service agent at the door. You guys have congressional hardpins. A staffer escorts you in. Every one of you has seen this or will in the Trump administration. This is not a mystery to anyone. Why was he put on what Eric had called, accurately so, the X? We use the exact same terminology as the military. The X is where that protectee or that limo with the protectee in it is. Why was he put on the X? You have an open threat. Ben has described, and your timeline lays out, was there for an hour. I'm not going to play any word games. Were they a threat or suspicious? Well, if you're a threat, it's because you're doing something suspicious. And if you're suspicious, it's because you could be a threat. These are silly, stupid word games. You know when it's not a threat? When your CSU or PI team goes and grabs the guy and determines he's not a threat. Until then, your question's accurate. You put him in the holding room, which is the point of the holding room.
Can I ask one more question? So I just want to follow that up. And you made the point earlier about counter surveillance. There were no counter surveillance teams there. There's a public domain videos of him, Mr. Crooks, wandering around. Was there anything in his behavior wandering around that if he would have had a counter surveillance team there, it would have triggered an interaction with this guy earlier?
I'm going to answer yes, but respectfully, and I know you understand, the CSU and PI teams are trained in very specific behavioral indicators that would give off, and speaking about them openly would probably give operational knowledge to bad guys. I know you understand that, but the short answer is not only one, but many behavioral indicators he was giving off that if we could talk in a secure setting, you'd be like, how did they miss this? The CSU team would not have missed it if they were there, which they weren't.
Thank you so much, Mr. Biggs. Thank you so much. This forum having come to order, I want to remind everyone that we will be going in 10-minute segments. Should there be a need to have a second round of questioning, we will then limit the second round of questioning to 5 minutes each. The first person who will start this out is the Honorable Andy Biggs.
Thank you, and thank you to everybody for being here today. Appreciate it. I want to start, if we're ready, if the video is queued, I want to show a short video, if we're ready.
Stunning new video tonight showing the moment Donald Trump's would-be assassin climbed onto the roof of that building just 2 minutes before he opened fire. Yeah, look, there he is. You can hear bystanders desperately trying to alert police. Authorities now using that video as part of the investigation.
Walk us through what you were seeing in the minutes before the actual shooting happened.
Well, there was a lot of people around the building that were complaining about some guy crawling up the building and then crawling up the roof.
Gentlemen, so we're going to bring him up for Can we bring him up for a couple of minutes? You get ready, McCormick. You get ready. I'll get you up here. The world will see a vibrant Republican.
Look, they're all pointing.
The Atlantic, maybe the Pacific.
Yeah, someone's on top of the roof. Look. There he is right there. Right there, see him? He's laying down, see him?
Yeah, he's laying down. And look what happened to our country. Probably 20 million people. And you know, that's a little bit over that short. It's a couple of months old, and if you want to really see something that says,
I hope he's turning this way. Be careful. According to a former agent, Secret Service counter-sniper teams should have scoped out and advanced all those areas where there were potential threats beforehand and known what the line of sight to Trump could be.
The fact that somebody was able to get within 200 yards with a rifle and be on an exposed rooftop, be seen by other people there, be seen by where it should have been cameras and drones and many other things in place. To watch for that, something broke down. That shooter with that rifle should have never been that close to the former president of the United States at a venue like this.
Thank you for showing that video. Appreciate that. And so we've seen aspects of those videos because those are public domain videos. One spectator was killed, and we express condolences to his family, Corey Comprador. 2 others were critically injured, David Dutch, James Copenhaver. And then narrowly escaping with his life was former President Trump. That's why we're here. And the timeline is probably too small for you to read, but I'm going to go over the timeline just briefly and with the experts here in just a second. But first, I want to acknowledge also our condolences to the 13 veterans killed in Afghanistan during that disastrous retreat. I also acknowledge our colleague Bob Good's presence today, his interest in this, appreciate his interest in this. Our former colleague Jason Chaffetz and Mark Morgan, we appreciate all of you being here today. So let's take a look at this from the local perspective. Ben, thank you for being here. Let's talk about the communications. Let's just start there. Was there a central communications center in place?
Yes, there were. That was provided by the Butler Emergency Services Unit.
And typically, was the Secret Service, did they have a person on the scene, a decision maker on the scene in case an emergency happened?
I believe that there were a Secret Service agent responsible for the scene. However, they were not, to my knowledge, co-located at the command center itself.
And so I want to make clear. So who was present in the communications command center that might have made decisions for Secret Service?
Secret Service, my understanding is that the information that was gathered by the command center, which would have been being operated by the Butler Emergency Services Unit and the commander in that capacity. He was responsible for relaying that information to a point of contact he had, and my understanding was that it was over a cell phone as opposed to in-person communications.
Is that normal to have a cell phone communication, or is there usually a body there that can make a decision?
In most security postures and events that I've been part of for these types of events, there is someone actually physically co-located for that reason. Due to the loss of cell phone service, which we experienced that day, a possible loss of radio communications that day. It's a very robust and fail-proof way to communicate because of the level of importance that's needed.
Did you, let's put it this way, were radios and communication implements offered to Secret Service by the local operators?
They were, yes.
And what was the form of the communication?
The form of communication would have been some type of encrypted law enforcement style radio.
And do you know, did the Secret Service avail themselves of that? Did they obtain those radios?
I believe they were offered, but I do not believe they were taken.
So they did not utilize the preferred mechanisms of communication that was offered to them?
That's correct.
Let's talk timeline for a second. So if we look at this timeline, it indicates to us, let me go 5:10, at 5:10 p.m., the shooter is identified as a suspicious person near the AGR building. Does that sound right to what you're understanding of the timeline?
Yes, sir.
And so at least some point, somebody had seen him by 5:10 p.m. That's an hour before the shooting. They adjudicated he was suspicious. And in testimony before the committees of Congress, they indicated to us that, when I say they, I'm talking Cheadle, Rowe, and Ray, the directors and interim directors of Secret Service and FBI. They indicated to us that there's a distinction between a suspicious person and a threat. And so you have a suspicious individual, you have a threat, there's an interim category as well. What's that interim category?
In our line of communications from a SWAT point of view and from a tactical point of view, our escalation of people that we encounter starts out as a suspicious person, then goes to a person of interest, and then from that level upgrades to what we refer to as a threat. And each one of those warrant a different response.
So the actual shooting takes place right about 6:11 p.m. So an hour elapses. How soon after the first identification of the shooter, which is at 5:10 p.m., did you? Well, before we get there, let's lay the foundation. What were you doing that day?
I was in a counter sniper role with one of my teammates in the southwest quadrant of the event center. Distance-wise, it was approximately 238 yards southwest of the podium and approximately 348 south-southwest of the shooter's final firing position.
And so he was not ever in your sector of responsibility?
Nor in my visual, nor sector, nor visual.
Okay.
I never had visual.
How soon after he's identified were you given information that, or did you hear information that there was a suspicious character that you should be alerted to?
Believe those text messages came across, and just to give some background on the text message tactics. So in this type of event, as tactical officers, we try to build redundancy in communications because it's so critical. We start out in a primary role, which would have been our radios that day, communicating on a designated channel amongst all the tactical operators. Because we were in support of the host agency, which would have been the Butler, the Emergency Services Unit, we also were running a secondary channel that was our local Washington Regional SWAT team channel. On top of that, the snipers and counter snipers, or I should just say the counter snipers, there were no snipers involved in our chat, had set up another chat to be able to provide any type of pictures or any type of relevant media or anything like that that we'd have been able to crosstalk.
So did you ever see any pictures? Were any pictures ever sent to you?
They were. The pictures came across the chat at approximately 5:38.
So about 30 minutes after the shooter, then at that time, he was a suspicious individual.
That's correct.
And when he gets up on the roof and he's crawling across the roof, is that what threat assessment would normally be made of that guy at that point?
Sure. I think it's important to mention that, from the time the original pictures were taken, the comment of him possibly having a rangefinder or that he was confirmed to have a rangefinder at that point would have automatically escalated him in our protocols from a suspicious person into a person of interest. And that would have warranted some type of either investigatory detention or a stop and question at that point when the rangefinder became a factor.
Ben, Mr. Shaver, at what point in that hour or before were you notified of the rangefinder, the use of a rangefinder?
Within minutes of the original information being passed. So I would say shortly after 5:38 p.m. or 17:38.
Thank you so much.
My time's expired.
Mr. Biggs is recognized.
Thank you, Mr. Chairman. I don't want to engage in that debate because I've got other stuff I want to do, but it just seems to me that the bail fund that commits fraud would be the culpable party criminally, just like we hold corporations and other institutions who commit fraud liable criminally. Leave that for a second and just say when you're concerned about interstate fraud, the particular organization that we're talking about, Interstate Commerce Clause, was receiving money from all over the country. So they could be engaged in fraud that touches that. So perhaps that might assuage you, maybe not. But I would just point out that the ranking member always, and I hear this often, they refer to the FBI data and say, crime is down. Don't believe your lying eyes. But here's the deal. The data for FBI changed the way they gather data. And now you have 40% of states, cities, and localities that don't even report. Then you have another 20% that only report part of it. So your data is bad. And when I talk about not reporting, we're talking places like New York City doesn't report. California doesn't report. So how can you even begin to say you've got accurate data? You don't. So let's go ahead and let's review a little bit of the Minnesota fund that we're talking about largely today.
If you were stuck in jail, who would come to bail you out? A Minnesota nonprofit has $35 million at its disposal to do just that.
It may just be the closest thing to a get-out-of-jail-free card. Jaleel Stallings, charged with attempted murder, prosecutors say he shot at a SWAT team during the riots in May. Someone paid $75 grand cash to get him out of jail. All three would probably still be sitting in jail if it wasn't for the Minnesota Freedom Fund. The group that paid their bail, no questions asked.
Last time I was down there, said, we hate it when you bail out these sex offenders, was exactly what they said.
Greg Lewin is the group's executive director, who says it's not about the crime, it's about the system.
I often don't even look at a charge specifics when I bail someone out. I'll see it after I pay the bail because it's not the point. It's just that it is not the point. The point is the system that we're fighting.
And now the Freedom Fund has a whole lot more money for that fight. Prior tax returns show in a good year they pull in about $100,000 in donations. But after the police killing of George Floyd and supportive tweets from Hollywood celebrities, they've now received more than $35 million in contributions.
As riots shook cities across the United States in 2020, then Senator Kamala Harris authored a little-known blog post urging the public to help demonstrators by donating to a bail fund. Harris is still fundraising on behalf of the controversial charity, according to Act Blue. Harris wrote in the blog post, quote, "I stand with those protesting George Floyd's murder." She then asked people to make a contribution to the Minnesota Freedom Fund. Harris, in June 2020, famously posted a tweet asking people to chip into the Freedom Fund. Since then, the bail fund has freed George Howard, who pleaded guilty to second-degree murder for shooting and killing a man in 2020 in Minneapolis. Sean Tillman of St. Paul, who was sentenced to life in prison this year for first and second-degree murder. Others who were freed in connection to the bail fund include Darnica Floyd, who was sentenced to prison in 2021 for stabbing a man to death, and a slew of serial domestic abusers. The fund also paid $350,000 to release a twice-convicted rapist, Christopher Boswell.
As a senator, as a politician, someone who has to respond to the constituents, what do these protests mean to the ability to affect change legislatively? Because
the only way we're going to truly achieve change is when there are people in the system who are willing or pushing to do it, and when there are those folks who are outside of the system demanding it. I am very clear that some of the success that we've been able to achieve around criminal justice reform would not have happened in recent years were it not for Black Lives Matter. And the intensity and the brilliance of that movement that forced at least that there would be some counterforce to the status quo, which is so reluctant for change, if not hostile to change. That's what these movements do. That where these systems are so invested and ingrained in what they call tradition, but is status quo, often which can be wrong-headed, these movements provide a counterforce to get us to where we need to be.
So when the current vice president solicited funds for that fund, she talked about freeing protesters. But you heard the director say, we don't even care what the charges are. We don't care what the charges are. It had nothing to do with protests. That might be fraud. Yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from Georgia, Ms. McBath, is recognized.
Thank you, Mr. Chair.
24. Thank you.
Without objection. Andy Biggs.
Thank you, Mr. Chairman. Let's get to this thing. The Muslim ban that was mentioned. What countries were involved in the Muslim ban? Anybody know? I know. Anybody want to take a guess? I'll tell you who they were. Iran, Libya, Somalia, Syria, Yemen, and North Korea. Is North Korea a Muslim country? No, it is not. What do those countries, 6 of those 7 countries, have in common? Actually, they have in common that 4 of them were on President Obama's DHS terrorist watch list. The other 3, the other 4 were considered terrorism safe havens. Only 12% of Muslims around the world were impacted. And besides that, and Mr. Clem knows this, Mr. Camerata knows this, I would hope Mr. Isaacson knows this, there were exceptions for every one of those countries to come in, so there was not an absolute ban. Another lie told by the left. How about separation? This notion of separation. More than 325,000 unaccompanied children have been misplaced by this administration, admitted to. New York Times did a study. We had the director in, and she admitted it. That's a separation. You know what these guys got criticized for? There's about 4,000 people, kids that were separated, and they found them all, but a few. These guys can't find 325,000, but you're not going to hear my colleagues say anything about it. U.S. crime rate is not down, contrary to what you say. And why do we know that? Does LAPD report? No. Does New York report? No. Does Miami-Dade report? No. Do more than 6,000 police agencies obviate any reporting? That's the correct thing. They don't report. So when you say New York is down, guess what, friend? They don't report to the FBI anymore. They don't report anymore. They stopped reporting several years ago. Why is it? They've told me it's too hard to report. And so that's what you're relying on. You know what the CBP said about Tren de Aragua? Tren de Aragua is now moving into the Northeast. And they are. But crime is down for you. That's good for you, my friend. CBP numbers, you said they're way down. I'm looking at CBP numbers right here. I'm looking at them right here. And you know what I see? I see, let's see here. August of 2023, 304,000. They're down, you're right, almost 50%. They're down to 160,000. But you know what's interesting about that? Jay Johnson, Obama's DHS secretary said, look, if you have more than 1,000 a day, you've got a crisis. Mr. Clem, is that a crisis? You've been there. How many, in the last year that you were sector chief, fewer than 8,600 encounters in Yuma, is that right?
In 2020, it was just approximately 8,800 arrests in Yuma. In 2021, it went up to 114,000. And then in 2022, it went up to 312,000. So we went up to over 1,000 a day just in Yuma alone.
Right. So if you take it, if you're standing on top of Mount Everest and you come down 1,000 feet, it may look like you've really descended a whole lot, but you ain't descended back to normal. And we're nowhere near normal. And that's the lie. That's statistics that you guys are rallying around. It just blows my ever-loving mind. How about the bipartisan deal, the so-called bipartisan piece of crap deal out of the Senate? Mr. Clem, I read your statement, and what did you say? You said something like this. You said, it failed to address the border security requirements still needed by the U.S. Border Patrol. If enacted, it would codify a mandatory nationwide catch and release scheme for all populations anytime there is limited consequences of detention or removal, even returning to Mexico, incentivizes more people to make the dangerous journey. That dangerous journey, that's what's inhumane, is it not?
That's correct. The journey is dangerous.
And so the bill that you referred to as a better bill was H.R. 2, which has been languishing over in the Senate for over a year now. That was a bipartisan bill. That was a bill that would have made significant changes along the border. Quit lying. Let me tell you, how about CBP1, the CBP1 app? How is that figured in? How's that counted in? Is that counted in your encounters? Between ports of entry or at the port? No, it's not counted in. And you know what? You know what those numbers are? And this will take you right back up to 2023 levels. 530,000 migrants, okay, that's the CHNV program. 813,000 came in under the CBP1. That takes you right back up to the 2023 levels, doesn't it not, Mr. Clem, Mr. Camerata? Yes, it does.
Yes, it does.
And then
yes, if you add them together.
Yeah, and then when you throw in the Cuba, Haiti, Nicaragua, Venezuela numbers, now you're back right at maybe even a little higher than the 23 numbers. And that's the point that none of you all want to admit. You want to dance around it and you want to say, well, now they're legal. They got some kind of legal status. You know what they've got? They've got an illegal parole status because parole under the INA is meant to be a singular, particularized parole status. But they've got categorical parole status here. And they know that's wrong, and that's where they should have stopped. And Mr. Chairman, my time's way over, but there's so much more to say here to rebut the crapola we've heard here today. Yield.
Mr. Chair, since I know time went over, can I just add one thing?
If he's adding, I'm going to add. You got time before we started. I didn't get that time.
Oh, well, that's because I'm the ranking member.
Yeah,
of the
who
committee.
cares if you're the ranking member? If you ask for a regular order, then do regular order.
Thank you, sir. As ranking member, can I, since you had more time, just one quick thing. I just want to clarify that actually the gentleman is actually incorrect. Both the states of New York and California, the city of New York City, the city of Los Angeles, do send their reports and their crime reports, and they are included in the data. And so I just think that the facts are important, and I won't.
Yeah, they are. So I demand time to respond to that.
I definitely won't correct every. I won't correct every misstatement. But I did want to correct those.
Yeah, because if you look at the Marshall Project itself, which is not a conservative group, they will tell you. If you look at the FBI data, more than 52% of agencies don't report all of their data to FBI, and that's the facts. Facts are a stubborn thing, and doggone.
And lastly, like having served as mayor for 8 years and had a police force of 600 police officers, did a great job. The city of Los Angeles, the city of New York, I can tell you, guarantee you, they report their data. Thank you.
Thank you, Mr. Chairman. And talking about extraordinary foolish, I know that was said earlier by one of our witnesses. It's not just cities, it's counties too.